Good afternoon, Mr. Farley. Now that everyone's here, we're gonna see Stephen Pierce first, correct, Mr. Doyle?
Yes, ma'am.
Okay, sounds
Here we
great.
go.
Thank you, Judge. Apologies for the delay.
That's okay. Mr. Pierce, I'm Judge Schultz with the Kansas City, Kansas Municipal Court. We are not here to talk about your county case or any other matter other than your city cases. It looks like if you are convicted of the trespassing that was alleged, the city is seeking jail time. So we have appointed an attorney to your case. Please leave your headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room. Mr. Lilich, I show that his county case is set for December 9th. He has a KDOC hold, but it looks like it expired, just so you know. And he has no, he's not held on our case at all.
All right, thank you.
You're welcome.
Send an invitation.
We will.
There we go. Got it. Thank you.
Thank you. Mr. Lilich, did you have an opportunity to speak with your client?
Yes, Your Honor. Thanks for allowing that time. I did review with Mr. Percy a plea offer that has been made by the city. I think we've reached an agreement to resolve this matter, and if I may, I'll summarize that.
Please.
Your Honor, it's Mr. Percy's understanding, pursuant to a plea agreement with the city, that he'll be pleading guilty to one count of trespassing. In exchange for that plea, it's his understanding the city will recommend a 30-day jail sentence and that he get credit for time served, and that the city will not be seeking any fine or court costs related to this plea agreement. Your Honor, I have explained to Mr. Percy that he has an absolute right to have a trial in this case, and should he wish to proceed to trial, he'd have the assistance of me and our office to prepare for trial. In lieu of proceeding for trial, he'd like to enter into this plea agreement, and he would ask that the court adopt it as its order.
Is that your understanding of the plea, sir?
Yes, it is.
Okay, so you would be pleading guilty to one count of trespassing. The city would be recommending a 30-day jail sentence. You've been in custody since August 30th, so you'd have credit for time served. And those rights that he was talking about, the right to a trial, assistance of counsel, review of discovery, confront witnesses, and to appeal the decision. Is that your understanding of those rights?
Yes, it is.
And knowing all of that, are you wanting to accept that plea?
Yes, I am.
Okay, I am going to sentence you to 30 days, give you credit for time served, and your city matter will be closed.
All
Thank
right,
you.
thank you.
Have a good day.
You too.
Just checking you were done here, Judge.
Yes, we are.
All right.
Thank you.
New pod next should be Jessica Tierney, Tearney. Pardon me, Judge, Miss Tierney's ready.
Sounds good.
Here we go.
Hello, Judge.
Good afternoon, Miss Tierney. It looks like the charges you have pending against you are a trespassing, domestic battery, and criminal damage. It looks like the city is seeking jail time if you are convicted. You do have a
Okay.
$1,000 cash bond pending. The last time that you were in custody, it looks like you had, well, let's see, October 11th, you were in custody. You were given an OR bond with a special condition. You were supposed to appear October 17th. You didn't appear October 17th, and then it looks like you got picked back up and booked yesterday. So Mr. Lilich is from the same office that Mr. Probst is from, and we're gonna have you leave the headphones on, and he's gonna talk to you for a moment.
Okay.
Thanks, Judge.
You're welcome. Just let the person who gave you the headphones know that you need to go to the virtual breakout room, okay?
The personal breakout room?
Virtual breakout
Oh,
room.
virtual. Okay. Okay.
Close enough.
Kind of the same.
Yeah.
Put you one-on-one with
Mr. Lilich, did you have time to speak to your client?
I did. Thank you, Your Honor. Your Honor, the city has made a plea offer to resolve Ms. Tierney's pending charges. I have reviewed that with her. She'd like to accept that plea offer, and I'll proceed to summarize her understanding of the plea agreement. It's Ms. Tierney's understanding that if she pleads guilty to one count of domestic battery, in exchange, the city will move to dismiss the count of criminal damage to property and the count of trespassing. It's also her understanding that the city will recommend that she be sentenced to 90 days in jail, be ordered to serve 2 of those days in the Wyandotte County Jail, and after serving those 2 days, be placed on supervised probation from the balance of that sentence for 1 year on the condition that she obtain a domestic violence assessment, that she not own or possess any firearm, that she have no violent contact with Kevin Tobler, and that she pay fines and court costs of $150. Your Honor, I have explained to Ms. Tierney that she has an absolute right to have a trial on all these charges, and that she would have the assistance of our office to prepare for trial and to help her with trial if that was how she wished to proceed. However, she'd like to accept this plea agreement to resolve these cases, and would ask that you adopt it as your final order. Judge, I also spoke with Ms. Tierney about her serving the 2 days in jail. My understanding is her preference would be that she just remain in custody through Saturday or Sunday if needed to serve the 2 days. And if the court approves that, we would just request that you set a date to order her to appear for probation. And we'd also ask that you allow her time to pay.
Okay. Ms. Tierney, I just want to make sure we're all on the same page. Is it your understanding that you'd be pleading guilty to that 1 count and the other 2 would be dismissed?
Yes, pleading guilty.
And is it your understanding that there would be that 90-day jail sentence? You'd have to do 2 days in jail and do 1 year probation, which includes getting that domestic violence assessment and following the recommendations?
Yes, I think that'll help a lot.
Okay, and during the time that you spoke with Mr. Lilich, I'm guessing he explained to you, but I need to make sure that you do have a right to a trial, assistance of
Yes.
counsel, review of discovery, confront witnesses, and you can appeal the decision if you're found guilty at a trial.
Yes.
Okay, and knowing all of that, do you want to accept the plea?
Yes, I want to accept the plea.
Okay, so I will sentence you to the 90 days. However,
Okay.
you have to serve 48 hours in custody. The remaining 88 will be suspended, meaning you don't serve them as long as you comply with probation.
Okay.
It looks
I was
like you were
wondering about that.
booked November 7th at 12:18 a.m. So they will release you November 9th at 12:18 a.m. Okay?
Okay.
So what we're gonna do is we will continue this to November 21st at 10 a.m. for you to
Okay.
check in with probation for the first time.
Okay.
What you'll need to do on that day is come to City Hall, come up to the 2nd floor, tell them that you're here for probation, and they will direct you to exactly where you need to go. The paperwork
Okay.
that we send over to the jail telling you when you're gonna be released will also tell that November 21st at 10 a.m. date, okay?
Okay.
All right, thank you.
Okay. Thank you so much, Judge.
Have a good day. Good
You
luck
too.
to you.
Thank you.
Good luck to you. All right, Judge, new pod, new floor, Edward House.
Okay, thank you.
Hi, Judge. Mr. House is here.
Okay, we are ready. Good afternoon, Mr. House. It looks like the charges you have pending from municipal court are allegations of battery, petty theft, criminal damage, and trespassing. If you are found guilty of the charges, the city is seeking jail time.
How much?
I don't know. You have been appointed an attorney though. So if you leave your headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room, you can speak to your attorney.
Yeah,
You're live when Mike's live.
yes, sir.
Mr. Lilich, did you have time to speak to your client?
I did. Thank you, Your Honor. The city has made a plea offer to resolve Mr. House's pending charges. I have reviewed that with him, and he'd like to accept that offer. And if I may, I'll summarize his understanding of the plea agreement.
Okay,
Your Honor, it's Mr. House's understanding that he'll be pleading guilty to one count of battery. And in exchange for that plea, the city will move to dismiss the criminal damage to property count, the petty larceny or theft count, and the trespassing count. It's his understanding that as part of the plea, the city will recommend a 180-day jail sentence, that he be ordered to serve 4 of those days in jail, and that after serving those 4 days, he'll be released on supervised probation on the balance for 6 months on the condition that he obtain an anger management evaluation, follow the recommendations, not violate the law, and pay a total of $150 fine. Your Honor, I have explained to Mr. House he has an absolute right to have a trial in this case, and that should he proceed to trial, he'd have the assistance of this office to prepare and help him with trial. Instead of proceeding to trial, he'd ask that the court adopt this plea agreement as the court's order. He has told me that today is the 4th day that he has been in the Wyandotte County Jail. So I've suggested to him it's possible that he will be released today and that the court will set a date and order him to appear at the probation office.
okay. Mr. House, is that your understanding of the plea offer, what Mr. Lilich just detailed?
Yes, ma'am.
And just to make sure we're all on the same page as to your rights, I want to make sure that you do understand that you do have a right to a trial, assistance of counsel, review of discovery, to confront witnesses, and to appeal the decision to Wyandotte County District Court if you would go to trial and were found guilty at trial.
Yes, I understand.
Okay, and I do show that you were booked in November 4th it was almost 1 p.m., 12:51 p.m. So you would have that credit for the 4 days. So what will happen is I'm willing to accept your plea. I'll sentence you to the 180 days. 176 of those days are suspended. We're going to give you credit for the 4 days. You will get out today. We have to finish the docket before we send all the paperwork over, so it could be still a few hours, but you'll get out later today. You'll need to appear at City Hall November 14th at 10 a.m. for your first probation check-in.
Yes,
They
ma'am.
will send you, when we send the paperwork over to the jail releasing you, it will detail that and they will give you a copy, okay?
All right.
Okay, so you'll get a copy before you leave jail today, okay? Thank you.
All right. Thank you.
All right, Judge New Pod, Richard Hudson.
Okay, thank you.
Judge, apologies, bad timing. The deputy's got to take a roll call of something, but we're here, so he knows we're here.
Thank you for letting us know.
Yeah, just a few more minutes.
Okay.
Pardon me, Judge, Mr. Hudson's ready.
Sounds good. Good afternoon, Mr. Hudson. I'm Judge Schultz with the Kansas City, Kansas Municipal Court. It looks like you have some traffic and misdemeanors pending against you. Just gonna read the allegations quickly. It looks like possession of marijuana, improper operation of a motorcycle, violation of a traffic control signal, failing to appear, battery, trespassing, battery on a law enforcement officer, resisting arrest, trespassing, and battery. The city is seeking jail time if you are convicted. You have been appointed an attorney. If you would please leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
Your Honor, it wasn't a motorcycle, it was a bicycle.
Bicycle, okay.
Okay,
So you need to go to the
No
virtual breakout room to speak to your attorney, okay? So make sure you tell that Mr. Doyle that you need to go to the virtual breakout room.
Yeah. All I was doing was riding home from the pawn shop trying to get back to the house. You know what I'm
Mr.
saying?
Hudson, you don't want to tell me the facts of the case right now. You need to get into a virtual breakout room to speak to your attorney. So tell the person that gave you the headphones that you need to go to the breakout room. He needs to go to the breakout room to speak to his attorney. Mr. Lilich, did you have an opportunity to speak to your client?
My last name is, sorry.
I did, Your Honor, and the city has made a plea offer for Mr. Hudson to consider, and I have reviewed that plea offer with him. I think that we have an agreement with the city to resolve these cases. I will need to point out some caveats with respect to the proposed plea agreement, and I'm not sure if the city will be in agreement with that or not. But once the city's back on here, I'm happy to summarize where I think we're at.
Apologies. Yep,
Okay.
I am back.
Your Honor, if I may.
Yes.
Your Honor, it's Mr. Hudson's understanding that the city has offered that if he pleads guilty to battery on a law enforcement officer and two other counts of simple battery, that the city would move to dismiss all of the other remaining charges that are pending before this court for Mr. Hudson. I have discussed a guilty plea to those charges with Mr. Hudson. Mr. Hudson would request that the city agree to a no contest plea in lieu of a guilty plea. If the city is in agreement with that, Mr. Hudson's understanding is that the city, as part of this plea agreement, would recommend that Mr. Hudson be sentenced to a 180-day concurrent underlying sentence, that he'll serve 6 of those days in custody, which, by the way, Your Honor, Mr. Hudson has advised me that he has been in the Wyandotte County Jail since last Friday. The plea agreement isn't specific on this, but I believe that the city won't be opposed to him having credit for time served since last Friday. And then thereafter, he'll be placed on supervised probation for the balance of that sentence for 1 year on a condition that he obtain an anger management evaluation, follow the recommendations, not violate the law, and pay a total of $150. Judge, I would note there was just a large degree of consternation by Mr. Hudson about this. I did tell Mr. Hudson that he has an absolute right to have a trial on all these charges, and that if he wished to proceed to trial, that our office would assist him with that. I have told him of his rights related to trial. After considering that, my understanding is that he'd like to accept this plea offer if the city's in agreement to a no contest plea, and if the city is in agreement for him having credit for time served.
Mr. Farley, what is the city's position first on a no contest plea?
The city is not objecting, Your Honor.
Okay, and the credit for the time served, I showed that he was booked November 1st.
Correct. Yep. No objections to time served, and then the rest.
Okay.
The rest underlying. Yep.
Okay. So, Mr. Hudson, is it your understanding that you'd be entering a no contest plea to 1 count of battery on a law enforcement officer and 2 counts of battery?
Yes, ma'am.
Okay. And I just want to make sure you do understand those rights that Mr. Lilich was talking about, that you have a right to a trial, assistance of counsel, review of discovery.
When you said no contest to, when you said no contest to battery, you meant like I don't agree with it. Like I'm not admitting to the battery.
So when you enter a no contest plea, you're not saying that you're guilty, but you believe that the city does have a case, and instead of going to trial, you would just rather enter a no contest plea.
Yes, ma'am.
Okay.
Yes, ma'am.
I do need to make sure you do understand that you do have a right to a trial, assistance of counsel, review of discovery, confront witnesses. And if you did go to trial, and you were found guilty, you would be able to appeal that decision. Do you understand all of that?
Yes, ma'am. No trial, none of that. The no
Okay.
contest is fine.
Okay, so what I will do is I will accept that no contest plea. I will sentence you to 180 days. However, I'm suspending 174 of those days. You'll get credit for the time that you have already served. You'll get out later today. We have to finish the whole docket before we send the paperwork over. We will continue this to November 21st at 10 a.m. for you to have a check-in with our probation at City Hall. The paperwork that the jail gives you when you're released later today shows you that November 21st at 10 a.m.
Yes, ma'am.
Okay, well, good luck to you, Mr. Hudson, and we'll see you November 21st, okay?
Yes, Your Honor.
Thank you.
Judge, just wanted to double check we're done here.
Yes.
Okay,
Absolutely.
well, if you've got my list, Marvin Miller is next.
Okay.
I'm pretty sure he's a two-man rule, so it may take a few extra minutes to get an extra deputy.
Okay.
All right,
Sounds
back soon.
good.
Mhm. Pardon me, Judge. I had to bypass Miller. They've got something going on. So I'm down in down at the ladies pod, White or Kearney. They also have something going on, but they're about to finish up. So we're kind of stuck.
Okay.
All right.
No
I'll be
worries.
back.
Just let
Okay.
us know.
You bet. Thank you. All right, Judge, we're ready. Kara Kearney is here.
Okay, we are ready. Good afternoon, Ms. Carney. It looks like you have been charged with 3 counts of petty theft, 1 count of battery, 1 count of battery on a law enforcement officer, and domestic battery. If you are found guilty, the city is seeking jail time. And I'm sorry, I skipped over this part. I'm Judge Schultz with the Kansas City, Kansas Municipal Court. You have been appointed an attorney. So if you would leave your headphones on, but tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
I need to speak to my attorney.
Thank you.
Breakout room.
Yes.
Put you in with public defender.
And Judge, I apologize. Who do we have here right now?
That is Miss Kearney, Kearney. I'm
Okay.
probably pronouncing it wrong.
All right. Thank you, Your Honor.
You're welcome. Yes, ma'am.
Judge Schultz, you are not muted.
Thank you. Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor. Thank you. And I reviewed with Ms. Carney a plea offer that has been made by the city. And I think that we are prepared to enter into a plea agreement with the city with just one minor caveat. And if I may, I'll summarize my understanding and Ms. Carney's understanding of that agreement.
Go ahead.
Your Honor, it's Ms. Carney's understanding that she's going to plead guilty to one count of domestic battery, and that one count of domestic battery and one count of battery on a law enforcement officer, and that in exchange for that plea, the city is going to move to dismiss one count of simple battery and 3 counts of larceny or misdemeanor theft, and that the city, as part of the agreement, will recommend that Ms. Carney serve a 180-day concurrent underlying sentence on the domestic battery on a law enforcement officer, and that she will actually serve 6 of those days in jail. And after serving those 6 days in jail, she'll be placed on supervised probation for 1 year from the balance of that sentence, on the condition that she obtain a domestic violence assessment, that she have no violent contact with Norenda Kearney, that she successfully complete whatever's recommended from that domestic violence assessment, that she not violate the law, and that she pay a total fine of $150. Your Honor, I have explained to Ms. Carney that she has an absolute right to have a trial in this case, and that if she chose to proceed to trial, that she would have the assistance of this office to prepare for trial and to present her case. I've also explained to her rights related to trial, and in lieu of proceeding to trial, she has opted to enter into this plea agreement. Your Honor, I would say that in discussing this with Ms. Carney, I think she has expressed genuine remorse. She, in discussing this with me, was surprisingly accountable for these charges. I think the court should take that into consideration with this plea agreement. Your Honor, I would ask that the court adopt the plea agreement as its final order. The small caveat here is the city wasn't specific insofar as whether she should get credit for time served. Ms. Carney has been in custody, she tells me, since last Friday. I have told Ms. Carney I would ask the city for clarification on that point. If the city is not opposed to her having credit for time served, since she has been in since last Friday, I believe we do have a plea agreement.
Mr. Farley, what is the city's position?
The city is not opposed to credit for time served, Your Honor.
Okay, so I want to make sure we're all on the same page here. Is that your understanding of what the plea offer is, Ms. Carney?
Yes.
And those rights that Mr. Lilich was talking about, the right to a trial, assistance of counsel, review of discovery, confront witnesses, and to appeal if you're found guilty at trial to the
Yes.
Wyandotte County District Court. Do you understand those rights?
Yes, ma'am. And I told him I'd rather plead guilty because I know what I did and I don't want to plead not guilty when I know what my consequences to my actions were. I told him I was well aware of what I was charged with and I would personally not want to go to trial because my plea deal, it seems like an easier solution than going to trial and confronting my mama when there's much more evidence to prove that I did it. And I'm not trying to be like disrespectful or anything, but I don't want to go ahead of a trial and make myself look dumb and try to make myself look innocent where there's body cam footage from the incident with me and my mom that can show that me trying to make myself look innocent will not prove anything, will make me look, it will look worse on my behalf. So I'd rather
Okay.
plead guilty and serve the time and do probation.
Okay. Ms. Carney, I will accept your plea. I will sentence you to 180 days concurrent. 174 of those days are suspended. You've been in custody since November 1st, so you've got that credit for the 6 days that they wanted you to do. You will get released. It will be a few hours from now. We have to finish the whole docket first, and then we'll send notice to, at the end, we send notice to the jail. So you'll get out today, but you'll have to appear in person November 14th at 10 a.m. for a probation check-in. The paperwork that we send to the jail, they'll give you a copy of it. It shows that you need to appear in person November 14th at 10 a.m. Okay?
Yes, ma'am.
All right. Thank you. Good luck to you.
Thank you.
And Ms. White next, Judge.
Okay. Good afternoon, Ms. White. I am Judge Schultz with the Kansas City, Kansas Municipal Court. Just give me one moment to bring your cases up.
Okay. Ooh, cases.
Okay, it looks like for the city, what you have pending are a failure to appear, battery, and trespassing. If you are found guilty of those, the city is seeking jail time. It looks like you had spoken to one of your attorneys, Mr. Probst, back in August. You were trying to figure out what was going on with your county case, so you had requested a continuance. If you would just leave your headphones on and let the person that gave you the headphones know that you need to speak to your attorney, we'll have you speak to Mr. Lilich. He is one of the attorneys that also works with Mr. Probst. And it looks like, Mr. Lilich, we show that she has a preliminary hearing in her county case December 6th. So if you would just please let Mr. Doyle know that you need to go to the virtual breakout room.
Mhm.
Thank you, Your Honor.
Thank you.
Thank you.
Put you one-on-one with your
Thank you.
Give me 1 minute.
Bless you.
Thank you. Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor, and I did review with Ms. White the plea offer that the city has made. Ms. White would like to have a trial on all her pending charges. In discussing that with Ms. White, my suggestion would be that the court set a review date sometime after her December 6th preliminary hearing, with the hope that she will be released after that and can personally appear in court. I discussed with Ms. White that on that date, we could set an appointment with her and also set a trial date, and then we can move forward and hopefully prepare for trial.
Mr. Farley, does the city have any objection to that?
No, it does not, Your Honor.
Okay, so just so everybody's aware, and Ms. White, so you're aware, you are not being held on the city cases, you're only being held on the county cases.
Yes, ma'am.
So after that December 6th date, depending on what happens, as long as the county releases you, then, you know, you would be released. Should we put this for a review December 13th? That way, if Ms. White is still in custody, we can be assured to see her by video. Otherwise, Ms. White, you would have to appear in person at City Hall at 1 p.m.
Yes, ma'am.
Okay. So that OR bond that you have will remain, and the appointed defense counsel will remain. We will continue this to December 13th at 1 p.m. We'll send that over to the jail. They put a copy in your property. That way, if you are released, you'll have the paperwork showing you need to appear December 13th. Otherwise, we'll see you on video, okay?
Thank you.
Good luck to you, Ms. White.
I appreciate that. Thank you, Your Honor.
Thank you. If you would just tell Mr. Doyle that you're done.
Okay, Mr.
Thank
Doyle, I'm
you.
finished. And thank you.
Also. Okay, Judge, yes, I got the message.
Okay.
It's back up for Mr. Miller. Let's see how that plays.
Yes, thank you very much.
Yeah, again, probably an extra little time. I'll have to get a 2-man up there.
Yes, thank you.
Okay, you bet. All right. Pardon me, Judge. Mr. Miller is just seconds away from sitting down.
Okay, thank you.
Out right there, please.
This is November month.
Good
say none of that?
afternoon, Mr. Miller. I am Judge Schultz with the Kansas City, Kansas Municipal Court. The charges that are pending against you in municipal court, the city is seeking jail time on those. You have been appointed an attorney. If you would please leave the headphones on and let the person that gave you the headphones know that you need to go to the virtual breakout room.
Tell him, I don't know. What about the $350
The
I got?
virtual breakout room.
What about the
gonna talk to your
$350?
attorney first. And Mr. Looks like Mr. Lilich, are you still? No, fudge. Okay, well, we'll wait until he gets back.
Shane, I'll let you speak up.
All right, thanks, Jim. Judge, I tried to talk to Mr. Miller today. That's not going to be productive.
Okay.
And I'm
Go
sorry,
ahead.
I was just gonna say physically, he removed the headphones, threw them down on the table and terminated the conversation.
Okay, well, obviously that's not productive. So here's, I wasn't here the last time. Here's the note I have from Judge Whitman. Tell me, gentlemen, what you remember from that. So her note from November 1st says that Mr. Lilich and Mr. Farley were there. And that Mr. Miller stated that he could post a bond of $350. So Judge Whitman indicated that he could post the bond and that she continued this for November 8th at 1 p.m., thinking that it would be an in-person hearing. Is that, gentlemen, your recollection of what occurred last time?
That is my recollection, Your Honor.
Okay.
Yep.
I know that he is not physically present anymore, but I'm assuming, Mr. Lilich, do you want to be heard on bond on your client's behalf?
No.
Okay. Okay. So what I will do is I will leave the bond at $350.
Well, Judge, I'm going to say this for the record. He has been held in the Wyandotte County Jail. You know, the court's going to draw what inferences it reasonably should from what happened today. I would ask that the court, though, since he has continued to be held in the Wyandotte County Jail, that the court consider reducing his bond to an OR bond. Judge Whitman did have a conversation with him last week, and he did represent that to Judge Whitman that he could post a $300 bond. Obviously, he hasn't been able to do that. He spent another week in jail. Frankly, I wasn't impressed by his dialogue with me, but he has been in jail another 7 days. I would respectfully request that the court consider him for a bond reduction to an OR bond.
Okay. So here's what I can see just in the recent past. Earlier in October, my note is from October 11th, that he was booked on city warrants and some new charges. At that time, I, sight unseen, I just went ahead and granted him an OR bond. He was supposed to appear in person October 14th. He did not appear in person at that time. And so we issued a bench warrant. And then prior to that, let's see, August, he was booked on city warrants. We gave him an OR bond. We continued him to September 9th. He didn't show then. July, we granted him an OR bond, continued him to August 5th at 8 a.m., and he didn't appear. So a lot of times when people don't appear, I try to give them the opportunity to tell me what's going to be different this time around. Mr. Miller is not here to give me that opportunity to tell me, other than Mr. Lilich, what you expressed, that he felt confident that he would be able to post that bond. And it's obvious that that has not happened.
Yes. And Judge, I have nothing to add to represent to you that it would be any different this time around.
Okay. Mr. Farley, what is the city's position on an OR bond? And you're muted, just so you know.
Your Honor, yeah, given I guess what's been going on since his last OR bond, I think the city would support the $350 bond, continuing with that.
Okay, here's what I'm going to do. I'm going to do what I would. Go ahead, Mr.
But I know it's not exactly my place, but for your information, Judge, before you go forward, I'm not so sure he's pursued the procedures to get to his money, which is in property. There are a very specific set of procedures that he needs to follow to go down to get the property, that then the money can go up and he can be bonded out. If you are going to hold the bond, I will make sure and have that knowledge passed to him. And then if he requests that we go down into his property, there is a form that he fills out and it can proceed from there. I only provide that to you and everybody, but to you specifically, that I'm not 100% sure he has ever requested to be that to be made available to him.
Okay. Last week, when he indicated that he'd be able to post the bond, Mr. Lilich, as far as you know, was there an indication that that money was in his property? Or did he say that like a family member was going to be able to post it?
No, he referenced that it was in his property, and that my recollection is that he referenced that he had it available to him, but I think the inference from that was that it was in his property.
Mr. Farley, do you have any recollection about that?
I recall he would be able to get it shortly. I don't remember, and maybe Mr. Lilich can correct me. I can't remember if it was Mr. Miller or someone else that said, "Let me make a call." but I do remember him specifically saying the $350, and it sounded like it was close in proximity. But I don't recall if it was actually in his property or not, or if he was the one that said, let me make a call about it.
And Mr. Doyle, obviously you have no idea if that money is actually in his property, right?
No, ma'am, I do not.
Right, because you
but I
wouldn't
do.
have access to it.
That is correct. I can only institute that procedure, and then it'll be up to the deputies to follow through. But I can assist if you want me to put that to him. And I too, because he is so loud and his conversation, I do recall him. My recollection is he was indicating it was in his pocket, which would have been in property.
Okay.
It was removed from his pocket and it was put in his property. I think it's a card in a wallet that's now in property.
Are they allowed to use, do you guys let them use card?
Yes, ma'am.
I know, okay, I know we only allow cash.
Yeah.
But, okay.
I credit cards I'm 100%
okay.
sure about. I don't
That's
know
okay.
about debit cards, but
Okay. I just, if your policy, was cash only and it was a card that he was referencing, obviously
Yeah.
that would not help him.
No, ma'am. I am aware at least credit cards are available. I would have no reason to think a bank tied debit card wouldn't be available as well.
Okay.
So just hopefully providing a little information to you
Okay.
for your decision making.
So what I'm going to do is I'm not willing to give him an OR bond at this point. What I will do is I'll reduce it to a $200 bond, and we'll put it on November 15th. And then Judge Whitman, since she was the one who had originally said the 350, she can make that decision as to whether or not to grant him an OR. Okay.
Thank you, Your Honor.
You're welcome. And I will note for the record, Mr. Lilich, that you did request an OR bond, okay?
I appreciate that, Judge. Thank you.
And
right.
Judge, I will, for whatever, I will definitely, before I leave here, represent and explain to Mr. Miller what he needs to do if he has the money available, the process that he has to initiate himself.
Thank you. I appreciate that because obviously if he does have it, we'd like him to be able to.
Yes, ma'am. Soon as we close here, I'll walk over and tell him.
Okay. Thank you. Thank you, everyone.
All right. Bye all. Good weekend. 3-day weekend.
Yes. Enjoy your holiday.